Hi, and welcome back to Beyond the Breathalyzer. For the past few weeks, we've examined landmark Supreme Court cases involving traffic stops and reasonable suspicion. Today, we're going to take a constitutional journey that was 35 years in the making. 6 cases, 9 justices, and a voyage through one of the most important stories in modern search and seizure law, looking at how we got from Prouse in 1979 to Heien in 2014. My name is Michelle Behan, and this is Fourth Amendment Friday. Beginning back in 1979 with Prouse, the Supremes eliminated the spot check, a random traffic stop. Officers were no longer able to make discretionary stops. Now they needed specific and articulable suspicion of illegal or criminal activity. So that is our starting point. No suspicion, no stop. But no one really knew what that meant. So then we had Cortez 2 years later to define it. The suspicion had to be focused on that driver, what's called particularized, and those objective facts observed by or known to the officer at the time of the stop. Cortez puts meat on the bones of Prouse. The suspicion has to be real, it has to be specific, and it has to be something the officer can explain or articulate. And that was the state of the law for 15 years until 1996 in Whren. That is a pretext case that changed everything. That case said that the officer's hidden motivation is immaterial, and if there is an actual violation, the stop is valid. So any violation, no matter how slight, objectively permits a traffic stop. Almost 20 years go by before we get to Heien in 2014, and that goes even further than Whren. It says the stop doesn't require an actual violation at all, just the reasonable belief that one occurred. So let's talk about the seeming tension between Prouse, where we began, and Heien, where we ended up. Because it seems like Prouse, which created reasonable suspicion and limited police discretion, has now given it away to Whren, where officers can follow you for miles, just waiting for you to make a mistake. And Heien, where stops that don't have an actual traffic violation still count as reasonable. But here's the short version of the arc. Prouse is the rule. Whren and Heien are the exceptions. They are narrow, limited, and fact-specific exceptions. And that takes us right back to where we began. No reasonable suspicion, no stop. But even narrow exceptions can have wide-range consequences. On paper, the exceptions are narrow, but in practice, they expand the ability of the police to intrude. So a big picture view of the Prouse to Heien line of cases gives us some recurring themes. First, any Fourth Amendment analysis is deeply fact-specific, and every move the officers must make has to be objectively reasonable. The second is that the burden rests entirely with the government, as it always has, to identify what suspicion, if any, existed at the time of the stop, or to identify how the officer's mistake of law was objectively reasonable. Finally, and here's the big takeaway, the Fourth Amendment is strong in principle, but it's fragile in practice. Unless we, lawyers, judges, and the public, insist on treating exceptions like actual exceptions. Government power must be constrained. It must be controlled and it must be checked. That cannot happen without defense lawyers demanding that the state meet its burden and requiring the police to ground every traffic stop in real and articulable facts. And protecting that boundary, holding that line, that isn't optional. That's my job, it's my duty, my obligation, and my privilege, not only as a defense attorney, but as a citizen of the great state of Arizona and the United States of America. And that does it for this edition of Fourth Amendment Friday. Until next time, stay free, stay fabulous, and remember your fundamentals. My name is Michelle Behan. I'm the host of Beyond the Breathalyzer, and your rights are my priority.